Hello, everyone. We have something we need to read. Hold on. I'm gonna do it. We're gonna read it. There it is. So we're going to take a little look at this letter sent to Mr. Langer from Mr. Van de Vender, Assistant Special Counsel, U.S. Department of Justice. The government submits this letter pursuant to Federal Rule of Appellate Procedure to notify the court of a document filed on November 22nd in connection with the appeal of an order imposed in New York v. Trump, which was referenced in the parties' briefing, and arises out of an incident that the district court discussed at the October 16, 2023 hearing. Specifically, the government refers to court to Exhibit E and to the attached affidavit, which is a sworn affirmation by an employee of the New York State Unified Court System assigned to the Judicial Threats Assessment Unit, discussing the defendant's October 3, 2023 social media post, which, quote, resulted in hundreds of threatening and harassing voicemail messages that have been transcribed into over 275 single-spaced pages, close quote. Because the parties referenced this matter in their briefs and the court inquired at oral argument about evidence of ongoing threats and harassment, the government respectfully submits Exhibit E and the related documents as supplemental authority. From the affirmation in opposition. Lisa Evans, an attorney duly admitted to practice law before the courts of the state of New York, affirms under penalties of perjury the truth of the following. I am a deputy counsel in the Office of Court Administration of the state of New York and am of counsel to David Nocenti, attorney for Justice Arthur Engeron, a justice of the Supreme Court, New York County. I make this affirmation in opposition to petitioner's request for a stay of the enforcement of the limited gag orders issued by Justice Engeron in the People of the State of New York versus Donald Trump. On or about November 16, 2023, petitioners filed within this Article 78 proceeding by order to show cause, seeking, inter alia, a stay of 4 gag orders issued by Justice Engeron in an ongoing trial before him, pending an adjudication of their Article 78 petition. On October 3, 2023, Justice Engeron issued a limited gag order prohibiting all parties in the underlying action from making any public statements about members of his staff. On October 20th, 2023, the court issued its second order sanctioning petitioner Donald J. Trump for violating the October 3rd, 2023 order for failing to remove a disparaging and untrue post of his law clerk from his website. The court issued its third order on October 26, 2023, again sanctioning Donald J. Trump for violating the October 3rd gag order on October 25th. When Mr. Trump, during a break in the trial, made the following statement to the press outside of the courtroom, quote, "This judge is a very partisan judge with a person who's very partisan sitting alongside him, perhaps even more partisan than he is," close quote. The court found that this statement was referring to his principal law clerk and in violation of the October 3rd order. On November 3rd, 2023, the court issued a fourth order prohibiting all counsel from making any public statements in or out of court that refer to any confidential communications in any form between my staff and me, close quote. Petitioner's application for a stay of the gag orders pending the adjudication of the within Article 78 proceeding should be denied. Petitioners have no likelihood of success on the merits. By this proceeding, petitioners are seeking the extraordinary remedy of prohibition, which, quote, lies only when there is a clear right, where there is a clear right, legal right, and only when the body or officer acts or threatens to act without jurisdiction over which it has no power over the subject matter, or where it exceeds its authorized powers in a proceeding over which it has jurisdiction, close quote. Quote, prohibition is never available merely to correct or prevent trial errors of substantive law or procedure, however grievous, close quote. Petitioners cannot establish that they have a clear legal right to the relief sought. Petitioners allege that the gag order violate their First Amendment right to free speech. While prior restraints are viewed with a strong presumption against their validity, this court has recognized that, quote, reasonable limitations may be placed on speech where an important countervailing interest is being served, close quote. Here, as set forth in the affirmation of Charles Hull and annexed hereto as Exhibit E, it is unquestionable that the conduct engaged by the petitioners, the deluge of the court's chamber's phone and the law clerk's personal cell phone, personal emails, and social media accounts with hundreds of threatening, harassing, disparaging, and anti-Semitic messages, which threatens the safety of court staff, is the type of countervailing interest being served that warrants the imposition of the limited gag orders imposed by the court. The First Amendment does not prohibit courts from limiting speech that threatens the safety of the court staff. Courts have broad discretion to control the conduct of litigants and attorneys in ongoing proceedings. Quote, the court must take such steps by rule and regulation that will protect their process from prejudicial interference, close quote. Here, the court reasonably determined that the limited gag orders were necessary for the protection of its staff and to protect the ongoing trial from prejudicial interferences. While freedom of expression is given wide range, it must not be allowed to divert the trial from the very purpose of a court system to adjudicate controversies, both criminal and civil, in the calmness and solemnity of courtroom procedure. Unquote. Petitioners also seek a stay of the sanctions imposed against Mr. Trump for violating the gag orders. The issue of granting a stay is moot since, as petitioners concede, Mr. Trump has already paid the sanctions. Based on the foregoing and for the reasons set forth in the affirmation, for a stay submitted by the New York State Attorney General, it is respectfully requested that petitioner's application for a stay of the gag orders and sanctions imposed for violating the court's gag orders be denied. Exhibit A. This is a transcript. Let's do this. Mr. Bender, do you recognize this document? The document, what's that? Repeat the question, please. Do you recognize this document? Yes, I do. What is this document? This is the representation letter for the DJT, the compilation of the personal financial settlement of Donald J. Trump as of June 30th, 2020. Mr. Wallace, if we could go to the bottom of this document, do you recognize the signature on the left hand of the screen? I do. Whose signature is that? Ellen Weisselberg. And in what capacity is Ms. Weisselberg signing this document? Chief Financial Officer and Trustee of the Donald J. Trump Revocable Trust. And do you recognize the signature on the right-hand side? Yes, I do. Whose signature is that? That is Donald J. Trump Jr.'s signature. And in what capacity is he signing this document? Executive Vice President of the Trump Organization and Trustee of the Donald J. Trump Revocable Trust. Mr. Wallace, Your Honor, we would like to ask that this document be entered into evidence. The court granted. It's in evidence. Let's see what this is all about. And these are the testimony from the case. Let's get to the different things where he said really naughty things. This is, here we go. On October 3rd, this is a Supreme Court of the State of New York County. On October 3rd, during a break in the trial, defendant Donald J. Trump posted to his social media account an untrue, disparaging, and personally identifying post about my principal law clerk. I spoke to defendants both on and off the record. Off the record, I ordered Donald Trump to remove the post immediately. Approximately 10 minutes later, Donald Trump represented to me that he had taken down the offending post and that he would not engage in similar behavior going forward. I then, on the record, imposed on all parties to this action a very limited gag order, quote, forbidding all parties from posting, emailing, or speaking publicly about any members of my staff, close quote, emphasizing quite clearly that, quote, personal attacks on members of my court staff are unacceptable, inappropriate, and I will not tolerate them under any circumstances. I further made clear that failure to abide by this directive will result in serious sanctions. Despite this clear order, last night I learned the subject offending post was never removed from the website donaldjtrump.com, and in fact had been on that website for the past 17 days. I understand it was removed late last night, but only in response to an email from this court. Today, in open court, counsel for Donald Trump stated that the violation of the gag order was inadvertent and was an unfortunate part of the process that is built into the campaign structure, close quote. Giving defendant the benefit of the doubt, he still violated the gag order. Contrary to defendant's claim on appeal, a finding of civil contempt does not require a showing that such disobedience was willful, end quote, quoting that case. Further, whether intentional or the result of mere campaign structure negligence, the effect of the post on its subject is unmitigated by how or why it remained on Donald Trump's website for 17 days. Moreover, a defendant may not evade liability for violating a court order by asserting that the violation was a result of the actions of one or more of the defendant's employees or agents. In the current overheated climate, incendiary untruths can, and in some cases already have, led to serious physical harm and worse. Donald Trump has received ample warning from this court as to the possible repercussions of violating the gag order. He specifically acknowledged that he understood and would abide by it. Accordingly, issuing yet another warning is no longer appropriate. This court is way beyond the warning stage. Given defendant's position that this violation was inadvertent, and given that it is a first-time violation, this court will impose a nominal fine, $5,000, payable to the New York Lawyers Fund for Client Protection within 10 days of the date of this order. Make no mistake, future violations, whether intentional or unintentional, will subject the violator to far more severe sanctions, which may include, but are not limited to, steeper financial penalties, holding Donald Trump in contempt of court, and possibly imprisoning him pursuant to New York judiciary law. Judge Angron is angry. Let's see. This is the other thing. Oh, here we go. There's another one. This is the other. On October 3rd, on the record, I imposed on all parties to this action a very limited gag order, forbidding all parties from posting, emailing, or speaking publicly about any members of my staff, emphasizing quite clearly that the personal attacks on members of my court staff are unacceptable, inappropriate, and I will not tolerate them under any circumstances. Sorry, I'm not adding the quotes. I further made clear that the failure to abide by this directive will result in serious sanctions. Despite this unambiguous order, last week I learned that Donald Trump had failed to abide by it by not removing, for a total of 17 days, that thing about my principal law clerk. Counsel for defendant stated in open court that the violation of the gag order was inadvertent. Taking counsel at his word, I imposed a $5,000 nominal sanction for the first-time violation of the gag order. On October 25th, during a break from the trial, Donald Trump made the following statement to a gaggle of reporters outside the courtroom. Quote, "This judge is a very partisan judge with a person who's very partisan sitting alongside him, perhaps even more partisan than he is," end quote. Quite clearly, defendant was referring once again to my principal law clerk who sits alongside me on the bench. Defendant's attorneys offered the explanation that Donald Trump was referring to Michael Cohen, who had been sitting on the witness stand. I then conducted a brief hearing during which Donald Trump testified under oath that he was referring to Michael Cohen. However, as a trier of fact, I find this testimony rings hollow and untrue. The Oxford English Dictionary defines, quote, alongside as close to, beside of, next to. Witnesses do not sit alongside the judge. They sit in the witness box, separated from the judge by a low wooden barrier. Further, Donald Trump's past public statements demonstrate him referring to Michael Cohen directly by his name or by a derogatory name, but in all circumstances, he is unambiguous in making it known he is referring to Michael Cohen. Moreover, the language Donald Trump used on October 25th mirrors the language he used in public statements to the press on October 2nd, wherein he inappropriately and unquestionably spoke about my principal law clerk, stating, quote, "This rogue judge is a Trump hater. The only one that hates Trump more is his associate up there, the person that works with him, and she's screaming into his ear," end quote. Using imprecise language as an excuse to create plausible ambiguity about whether defendant violated this court's unequivocal gag order is not a defense. The subject of Donald Trump's public statement to the press was unmistakably clear. As a trier of fact, I find that Donald Trump was referring to my principal law clerk and that, as such, he has intentionally violated the gag order. This is the second violation of the court's gag order in less than 1 month since this trial commenced. Accordingly, this court imposed a fine of $10,000 on defendant Donald Trump. Further, Donald Trump is ordered to post proof of payment of this fine and the one imposed on October 10th within 2 days. Exhibit D. And then we have another statement from Judge Angron. This one is dated 11/3. Let's see. The new information. We are up to speed, an additional $10,000. I imposed the gag order only upon the parties operating under the assumption that such a gag order would be unnecessary upon the attorneys, who are officers of the court. Over the past week, defendants' principal attorneys, namely Christopher Keyes, admitted pro hoc vice, I'm sorry, I didn't say that right, Alina Haba, have made, on the record, repeated inappropriate remarks about my principal law clerk, falsely accusing her of bias against them and of improperly influencing the ongoing bench trial. Defendants' attorneys have made long speeches alleging that it is improper for a judge to consult with a law clerk during ongoing proceedings, and that the passing of notes from a judge to a law clerk or vice versa constitutes an improper appearance of impropriety in this case. These arguments have no basis. Pursuant to New York Criminal Code, Civil something, a judge may consult with court personnel whose function it is to aid the judge in carrying out the judge's adjudicative responsibilities, or with other judges. This is precisely the role of a principal law clerk in the New York State courts. Moreover, ethics advisory opinions have further emphasized that, quote, the relationship between a judge and his or her law clerk is one of particular trust and confidence. Although a judge and his or her law clerk are, of course, not partners, the two engage in the kind of professional interchange that might be found between longtime colleagues in a law firm. As I have stated on the record seemingly to no avail, my law clerks are public servants who are performing their jobs in the manner in which I request. This includes providing legal authority and opinions, as well as responding to questions I pose to them. Plainly, defendants are not entitled to the confidential communications amongst me and my court staff, who are hired specifically to aid me in carrying out my adjudicative responsibilities. Nor are they entitled to continue referencing my staff in the record. Defendants' attorneys have had ample opportunity to make their record, and they have at length. Indeed, I will assist them by repeating here that I will continue to consult with my staff, as is my unfettered right, throughout the remainder of the trial. Accordingly, defendant's record is now fully preserved for the duration of the proceedings. Defendant's attorneys may refer back to this blanket statement in their appeal as they deem appropriate. Defendants may reference my staff as is appropriate to ask about scheduling issues or the management of the trial, which is an integral part of their jobs. What they may not do is make any further statements about internal and confidential communications, be it conversations, note passing, or anything similar between me and my staff. Defendants' First Amendment arguments in opposition to the imposition are wholly unpersuasive. This gag order is as narrowly tailored as possible to accomplish its purpose, which is to protect the safety of my staff and to promote the orderly progression of this trial. As I have made clear as the judge in this case and as the trier of fact, the gag order does not apply to me. However, I will not tolerate, under any circumstances, remarks about my court staff. The threat of and actual violence resulting from heated political rhetoric is well documented. Since the commencement of this bench trial, my chambers have been inundated with hundreds of harassing and threatening phone calls, voicemails, emails, letters, and packages. The First Amendment right of defendants and their attorneys to comment on my staff is far and away outweighed by the need to protect them from threats and physical harm. Thus, for the reasons stated herein, I hereby order that all counsel are prohibited from making any public statements in or out of court that refer to any confidential communications in any form between my staff and me. Failure to abide by this directive shall result in serious sanctions. Exhibit E. This is Charles Holland, who is not a party to the action, affirms the following to be true under the penalties of perjury. And the date of this document is 11/23. Oh, wait, no, maybe not. Sorry, this is the entire document. Forgive me. We'll find it. Charles Holland. Okay, I am employed by the New York State Unified Court System as a court officer captain in the Department of Public Safety. I am assigned to the Judicial Threats Assessment Unit of the DPS. As such, I am familiar with threats, disparaging comments, and harassing messages made to and about Justice Angeron and his staff via emails, telephone, and social media outlets. I am also aware that personal emails and cell phones of his law clerk have been compromised. I make this affirmation in opposition to petitioner's request for a stay of the enforcement of the limited gag orders issued by Justice Angeron in the trial. The DPS provides security services at every New York State courthouse to ensure the safety and security of judges, non-judicial personnel, court visitors, litigants, and anyone entering the courthouse. The Judicial Threats Assessment Unit, okay, that's not going to be easy, JTA, is made up of uniformed personnel who are trained on how to carefully analyze reported threats in order to determine possible courses of action to secure the safety of the judges. Once a judicial threat has been reported, court administration, local law enforcement, and court staff are notified by trained uniformed personnel that a threat exists. After a reported threat is carefully analyzed and is determined to be credible, security measures are put in place to ensure the safety of the judge's staff, and family members. Prior to the commencement of the trial in the underlying matter, the Judicial Threats Unit became aware of harassing and disparaging comments and threats made about and toward Judge Angeron on social media. Once we conducted our assessment that found the threats credible, we contacted local law enforcement, the FBI, and Homeland Security to devise the appropriate security measures that would be implemented in order to protect the judge, his chamber staff, and those closely associated around him, including his family. On or after October 3rd, the threats, harassment, and disparaging comments increased exponentially and also were now being directed at the judge's law clerk. Specifically on October 3rd, Mr. Trump posted to his social media account a picture of his law clerk with the United States Senator Chuck Schumer with the added caption, quote, "Schumer's girlfriend name is running this case against me. How disgraceful. This case should be dismissed immediately." Although Mr. Trump did not directly threaten the law clerk, the comments made in his post resulted in hundreds of threatening messages and harassing voicemail messages that have been transcribed into over 275 single-spaced pages. Her personal information, including her personal cell phone number and personal email addresses, have also been compromised, resulting in daily doxing. She has been subjected to, on a daily basis, harassing, disparaging comments, and anti-Semitic tropes. I have been informed by her that she's received approximately 20 to 30 calls per day to her personal cell phone and approximately 30 to 50 messages per day on combined sites of social media, LinkedIn, and 2 personal email addresses. She also informed me that since the interim stay was issued, lifting the gag orders on November 16th, approximately half of the harassing and disparaging messages have been anti-Semitic. Judges who receive threats are advised not to make public statements discussing the threats or any security measures that may be in place, because doing so could compromise the security measures put in place to protect them and those around them. The threats against Justice Angeron and his law clerk are considered to be serious and credible and not hypothetical or speculative. In order to provide this court with the seriousness of the threats being made against the justice and his staff, below is a representative sample of the hundreds of threats, disparaging and harassing comments, and anti-Semitic messages that are directed at the judge and his staff. The following are transcripts of messages left on Justice Angeron's chamber's telephone. I am not going to read the comments. So I'm gonna show them in the document, and I'll link the document, but I'm not gonna read them. And this is just a sample. This is just a sample. This is what they've done. This is what they've done. The messages received by Justice Angeron and his staff every day has created an ongoing security risk for the judge, his staff, and his family. The implementation of the limited gag orders resulted in a decrease in the number of threats, harassment, and disparaging messages that the judge and his staff received. However, when Mr. Trump violated the gag orders, the number of threatening, harassing, and disparaging messages increased. On a daily basis, the judge and his staff are being inundated with hundreds of harassing and threatening phone calls, voicemail messages, and emails that has resulted in the Judicial Threats Assessment Unit having to constantly reassess and evaluate what security protections to put in place to ensure the safety of the judge and those around him. Signed, Charles Holm. All right. Thank you so much for coming. I hope your Friday's going well, and hope for those of you watching this today on Friday, for others, happy day. Have a good one. Have a great weekend.